Under Section 1 of the Sherman Act, horizontal agreements, which are agreements by two or more competitors to restrain trade, also known as a cartel, are generally illegal per se. Conversely, vertical agreements, which are agreements between firms at different distribution levels to restrain trade, are generally subject to a rule of reason analysis. But what about conspiracies to monopolize that are partly horizontal and partly vertical? May a plaintiff maintain an antitrust action based on allegations of horizontal and vertical conspiracies of collusion and exclusion? The Seventh Circuit considered this question in JTC Petroleum versus Piasa Motor Fuels. JTC Petroleum and Piasa Motor Fuels were two road repair contractors and paving companies in southern Illinois. As pavers, JTC and Piasa both relied on asphalt companies to produce and supply them with the asphalt they would apply to the surface of the roads. In the 1990s, JTC suspected that Piasa and other paving companies were colluding by deciding not to compete against each other when local governments put paving jobs up for bid. In addition, JTC suspected that the paving companies paid the asphalt companies not to sell their asphalt to JTC or any other company that refused to join the cartel. Subsequently, JTC sued Piasa, the paving companies, and the asphalt companies in federal district court, alleging violations under Section 1 and 2 of the Sherman Act. To support its claims, JTC presented evidence that the paving companies paid much higher prices for asphalt than paving companies did in a nearby region with similar operating costs. To this end, JTC theorized that the prices in its region were higher because the prices included compensation to the asphalt companies for their agreement not to sell to JTC or others that competed with the cartel. Further, JTC presented evidence that the reasons the asphalt companies gave to JTC for refusing to sell it asphalt were pretextual and insubstantial. After filing suit, JTC settled out of court with the asphalt companies and 3 of the 6 paving companies. The remaining paving companies, including Piasa, then moved for summary judgment, which the district court granted. JTC appealed to the Seventh Circuit.